Settlement and Policy Subcommittee meeting. I think I want to start with Theo. Did you want to talk about the issue we've had already tonight?
Sure. There have been just a few interruptions at the beginning of the meeting where folks have been coming in and making noise. So I'll be sure to handle that as it arises, but I don't expect it to arise anymore. And hopefully it won't. So it's good to see you all. Thanks all for coming. My name is Theo Latta. Use he, him pronouns. It's good to see you all.
Thank you, Theo. So yes, and just a reminder, if you're not talking, if you could put yourself on mute, that'd be terrific. So I want to begin tonight with introductions. I'm Ann Campbell. I use she, her pronouns, and let's just, Theo Latta already introduced himself. How about Jared's the next on my screen? Jared, can you introduce yourself?
Yeah. Hi, everyone. My name's Jared Hager. I'm an assistant U.S. attorney. I represent the United States in a case with the city of Portland. And I'm here in my role as the monitor of a settlement agreement for police reform. I use he, him pronouns. And yeah, thank you for having me.
Thank you, Jared. Tia?
Okay. Hello, my name is Tia Palafox. I use she, her pronouns. I'm on the Behavioral Health Subcommittee with PCCEP as a member, new member.
Thank you. Heidi?
Thanks, Anne. Hi, everyone. Heidi Brown. I'm with the City of Portland City Attorney's Office, and I've been handling the DOJ settlement agreement for the city for the last while. Although at some point, when you get to Vamshi Reddy, she and Sarah Ames are our newest addition to our office, and I'll let Vamshi introduce herself when you get there, but really excited to have her on, and she and Sarah will be transitioning from me over to the two of them, and they'll be running with the baton and helping us get into substantial compliance and working on policing overall within the city and within the community. So if I didn't say it already, my pronouns are she and her, and glad to be here tonight. Thanks.
Thank you, Heidi. Let's go ahead with Byron, please.
Good evening, everybody. Byron on PCCEP member and Behavioral Subcommittee.
Thanks, Byron. Okay, let's go to Vamshi.
Yes, hi, and hello, everyone. Thank you so much for having me tonight. My name is Vamshi Reddy, she, her, hers. I am a new city attorney, deputy city attorney. I am very excited to be here and to work with you all and to learn from you all. And I am very excited to be working for the city attorney's office on this team that is so committed to transforming policing in Portland to better serve the needs of the community. If you have any questions about my background, I'm happy to share a little bit if you'd like, but that is totally up to you, or we can just talk in person when I see you. Thank you.
Thank you very much. And I know that you're new, and I saw you in the courtroom earlier this week. Thank you for joining us. Gloria?
Gloria Canson. I'm on the PCCEP Youth Subcommittee, and I am currently working with PCCEP members trying to make sure that we have a better Portland. It's good to be here tonight. It's good to see so many of you dedicated people here tonight. So, thank you, Anne.
Thank you, Gloria. Amy?
Yeah, good evening, everyone. Amy Anderson here. I'm chair of the Behavioral Health Subcommittee.
Thank you, Amy. Barb? There's two Barbs. Barb Rainish.
You caught me off guard. I was putting it in the chat, Ann. Hi, my name is Barb Rainish. I'm a PCCEP groupie and member of the PCCEP Behavioral Health Advisory PCCEP Behavioral Health Subcommittee. And not a PCCEP member, but a new member of the BHUAC. So I'm excited.
Thank you.
Oh, she, her pronouns.
Thank
Citizen.
you. Thanks for being here. Are there any other PCCEP members that are here this evening? I think I got everyone. So tonight, and the rest of the people that are here tonight, if you can put in the chat your name and who you're affiliated with and your pronouns, that would be terrific for the rest of us. And we're going to start this evening. Our entire session is going to be talking about the court hearing that was on this week and the status of the City of Portland DOJ settlement agreement, which is a basis for our PCCEP committee. So I'd like to start with, I was in the courtroom and as you may know, and you may have read, Judge Simon ordered one more mediation so that there's a few issues, and I'll let Jared and Heidi, the attorneys from the city, and Vamshi, if she'd like, talk about some of the issues that the judge wants them to take another look at. And then we will have questions after that. So let's start with, how about Heidi?
Thanks, Ann. So for anybody who just came on, my name's Heidi Brown, she, her pronouns, and I'm with the city attorney's office. And I've been working on the settlement agreement for a while now and took over when Tracy Reeves, our last city attorney, retired. So the DOJ and the city and PPA and the AMAC and the MHA, so the Albina Ministerial Alliance Coalition and Mental Health Association, we all went to mediation and we attended 5 mediation sessions where we talked. And as you all know, the Department of Justice sent out a notice and had suggested that there would be 9 remedies they would like to see the city adopt. And the mediation was where we were able to sit down and actually talk about those with federal court judge Stacey Beckerman, who was, I just have to say, was amazing and really helpful. So we went through the 9 remedies, and I will go over with you what, if it's all right with you, Jared, I can go through the remedies. Okay, great. So what we're doing is doing an addendum to the existing settlement agreement and adding on 9 more remedies that the city would then be required to comply with, in addition to the ones that are already in agreement. So this doesn't create some new remedies that supersede the old ones. The old ones are still in place, and these will then also complement them. And these are really focused on the concerns that the Department of Justice and others, and probably within the city too, that we had from 2020 and the challenging year that we had, and finding ways to address those concerns that came up that relate to the settlement agreement, and find ways to set up a system so that that won't happen again going forward. So the first remedy is one that has to do with, at the time that reports are submitted, that are use of force reports, and then the after action reports, which then review those force reports to ensure that they're in policy. There were concerns because they are not time stamped, that the Department of Justice couldn't tell exactly when they were submitted to ensure that the timelines that we are required to follow under the settlement agreement were being met. And there were also, they wanted to ensure that if there were edits being made to the use of force report based on like a review by a higher level officer. So an officer has a event with somebody where there's force used, they write a force report, they give it to a sergeant who then reviews it and looks for whether it's in or out of policy. And occasionally the sergeants might ask, might raise a concern about, hey, I don't see you answering this question or that question, and send it back. And the DOJ wanted to be sure to see that if there's some edits made, they wanted to see that. So the first remedy is to ensure that when the force report is submitted to the sergeant, it gets time stamped. And then if it's sent back to the sergeant, that is time stamped. And that if there's edits made, that DOJ can then see those edits. So that was the first one. And that eventually, as many of you probably know, the city is in the process of switching our police system from an older system to Office 365. And once we have Office 365 on, it will track that much more readily. But in the meantime, we came up with an interim solution to address DOJ's concerns. So that was the first one. That was the first remedy that that was the first remedy that we that the DOJ and the city had I would say tentatively agreed to, because the any changes to the settlement agreement or additions to it have to be ultimately approved by the city council, and then also by the assistant attorney general on the civil rights side for the US DOJ. So we have an approval process on each side that we have to go through. So on our side, we hadn't yet been able to have a council vote. So the next remedy that we came up with was to do a more thorough assessment of 2020 and to kind of do a critical assessment of what happened. And the agreement is that we would hire an outside entity. So somebody that, a contractor that generally does assessments of cities and their uses of force in protests. There are a variety of folks who do that more regularly. And we've talked about people that would be acceptable to both the Department of Justice and to the city, and would have them come in and do a very thorough analysis of the crowd control events in 2020. And then they would create a public facing report so that you all would get to see a copy of that. Initially, it would come to the city. We would then, within 60 days, do a public facing response to that report. And as you can see in the document that was filed, and if you don't have that, Theo, I'll get it to you and you can post it on the PCCEP website. So you just let me know.
I put it in the chat, Heidi.
Oh, you're the best. Thanks.
Everyone
Jared.
should have it. I think it's a document, ECF 269-1.
Thank you so much. So that's
Yeah.
great. So, the expectation is that assessment would happen within 180 days. If the contractor needed some additional time, then we would go back to the DOJ and let them know and explain what was needed and why. But the anticipation is that it happened relatively soon, so that the feedback and information we receive about 2020 is something that the city can then learn from and implement some changes based on that as needed. The next area, and I apologize, I've got the agreement up on one screen and you on another screen. So if you see me looking back and forth, that's why. The next section is related to overtime costs. So one of the issues that came up in 2020 had to do with training. And as many of you know, the city was partway through training for police officers when COVID started and everything shut down. And at that point, only about half of the officers had received the scenario-based training. There was additional training that could be done virtually. So folks got that training, but the hands-on scenario-based skills training, which is a requirement of the settlement agreement, was not able to occur for these other folks, originally due to COVID. Then we had protests. And the original plan was to start that back up in August of 2020. But at that point, the police bureau's overtime budget was so taxed that they weren't able to afford to do that. And so the Department of Justice wanted to ensure that, and we agree, that the training has its own overtime budget assigned to it to ensure that we meet our training needs and that overtime costs are not a problem with that. So we're creating a separate budget line that will be specific for overtime for training. And that way we'll ensure that we don't end up in the same boat that we were in last year related to costing being a problem for that. The next paragraph has to do with what we're calling the Dean of Training. This would be a civilian who has qualifications in teaching and education, and they would be working alongside the captain of training and separately developing the education, the curriculum for training for police, and looking at best practices and things of that nature related to training. I will tell you, the Bureau is really excited about this. This is something that PPB has been interested in for quite a while and didn't have the funding for, and DOJ also saw the value of that and then included that as one of the things because of our issue last year with training. And some other issues that came up in 2020 related to people understanding the policies and having misunderstandings around them. So that was the next agreement, was that we will hire on, as I said, what we're calling the Dean of Training. I'm sure they'll have a different title eventually, but and we have some timelines regarding that we would post the position within 90 days of getting the funding. And the funding is something that we are requesting in the current budget process that is going on right now. Excuse me. So some of you may know there was a hearing today on the budget, and this is the city's budget process. We adopt a full budget for the fiscal year, July 1 through June 30th. So we adopted that in July, and then in the fall of each year and in the spring of each year, we look at the budget to see, have there been changes within the city or the needs of the city that that we need to address right away, and there can be adjustments made to that budget. And so that went for our first hearing today. And if anybody's interested, the next hearing is next week, November 17th. The council will take the budget up for a final vote on it. And within that, you'll see a number of these things that cost money for the city. Those are in that budget process. And so a lot of these dates were related to that budget process. And then we'll look at hiring somebody within 150 days after we posted it. And just so you understand, there's a background screening that's part of hiring anybody at PPB. And so that's why it's a little bit longer time. The next paragraph relates to investigations. So the independent police review, the IPR, independent police review, would identify 3 categories of personnel and investigate whether or not there were policy violations. The first category is for police lieutenants and above at that rank who trained rapid response team members to believe they could use force against individuals during crowd control events without meeting the requirements of PPB Directive 1010. The second would be for the Police Bureau incident commanders or their designees. And those folks would be within the rank of lieutenant or above who directed or authorized any officer to use force in violation of PPB Directive 1010. And just for anybody who doesn't know, 1010 is our use of force directive. Or who failed to ensure that our force reports and after action reports from the crowd control events in 2020 were completed as required under our crowd control management policy. The third area of investigation by IPR is for commanders and above who failed to timely and adequately clarify misunderstandings and misapplications of police policies governing the use, reporting, and review of force during the crowd control events of last year. And then finally, within that, once the investigation is complete, the police commissioner and or the chief of police, so depending on the person's rank, it could be either one of those two people, will hold accountable those investigative members of the rank of lieutenant and above who are determined to have violated PPB policies. And just as a note, that is one of the areas where we discussed in court yesterday that Judge Simon wants us to go back and discuss further with the Albina Ministerial Alliance Coalition and with the Mental Health Association. The next paragraph is something that we were able to do this year, and we will continue to do going forward, which has to do with the presentation of the annual report. So each year, look at Theo's dog, that's cute, sorry. Each year, the police chief issues a report of that covers the prior year and talks about how police handled matters. They look at stops data and other policing data information that we have, and kind of look at where are things going and where have things been, and are we improving where we want to improve. It kind of helps us look at how we're doing overall and where we could do better, and where we're doing well. And so that report is not only given to council, but it also is a report that is provided out at each precinct. And then there's also some education that's required that the city gives. And the precinct meetings are ones where the community members attend. And so we did invite a number of people and got the message out as much as we could, including through the PCCEP, and appreciate your help with that. And a number of people attended those meetings at each precinct, where the chief of police and then the precinct commander was able to share about the report, talk about the stops data and other constitutional rights that community members have, and answer questions from the community. So what we've agreed is that since in 2020, one of those precinct meetings did not happen, the remedy was to ensure that each year that we will do that no later than September 20th. And that will just keep going forward, that deadline will appear going forward. The next paragraph, it relates to body worn cameras. I know there's been a lot of media on this and a lot of discussion about body worn cameras. So the city would implement a body worn camera program and adopt a policy that is subject to the review and approval provisions of the agreement. And that body worn camera policy, though, is first, the city will comply with our collective bargaining agreement requirements. So some things in the body worn camera policy may very well impact mandatory subjects of bargaining, things that we have to bargain with the union. And so the DOJ understood that and included that we would have time to be able to do that with the police union and go through that process. And then in addition, if we get through that collective bargaining process and the outcome is one that the Department of Justice is not satisfied with, then they retain the right in that to bring us back to court and talk to Judge Simon about the initial concerns around us getting out of substantial compliance and the remedy related to body worn camera policy that the DOJ is asking for. So ultimately, the court would retain authority if the outcome of bargaining is not one that the Department of Justice is satisfied with, and that they feel remedies the issues that arose in 2020. Part of this process in the body worn camera policy will be to have the compliance officer, Dennis Rosenbaum, gather public input on the use of body worn cameras. And then they would then provide that information to both the DOJ and to the city and to the other parties to help us in drafting a policy. So I would encourage all of you to please watch out for that when the COCO seeks your input. Please be sure to share that in comments so that we have your feedback. I know it's very important. A lot of people have strong feelings about body worn cameras, and we really welcome that information back. So that was another piece of the body worn camera policy. And I think that summarizes what we agreed on body worn camera policies. And then the last paragraph has to do with the oversight, the Community Police Oversight Board. So as I'm sure you all know, the voters of Portland passed a ballot measure that authorizes the establishment of Community Police Oversight Board. And there is a commission that has been seated and will be starting to meet, I think, really soon. And they are tasked with coming up with, excuse me, I'm sorry. They're tasked with coming up with the structure and framework, a recommendation for the structure and framework for that board. So what does it look like? How is it going to run? What is the process that you go through? So when there were certain types of police misconduct that the board is specifically authorized to investigate and then make determinations about discipline. And then also they have some flexibility to include other types of police misconduct if they feel that's appropriate. So that's the kind of stuff that the commission will be tasked with, creating that framework from the outline that is in the charter amendment. And so one of the concerns that the Department of Justice had was that the folks at Independent Police Review had some question or concern about their ongoing jobs, since the Community Police Oversight Board will replace the IPR. And the Department of Justice wanted to ensure that we don't lose the folks in IPR and not have folks who can do the investigations that IPR needs to do and all that work that they do that's so critical for us. And not have them sufficiently through the time of standing up the new Community Police Oversight Board. So this last paragraph is to address that. And what we agreed on was that by January 1 of 2022, so in just less than 2 months, that both the city council and the auditor will present some idea, their own plan for how that transition could look, and we'll present that to the Department of Justice. The Department of Justice will decide whether one or both or neither of those plans address their concerns regarding this transition and ensuring that IPR employees are motivated to stay with the city throughout this transition to the new board. And to the extent they, whatever they approve, then it comes back to us, and then council will adopt a plan that they feel is appropriate within what the Department of Justice has approved. So Department of Justice will give us an initial yes or no on things. Whatever they give us yes to will then go to City Council to adopt. And then once that is, then we'll actually attach that to this agreement. And then within 18 months, once the court enters the actual order of the court, and I think Jared was talking earlier about that process. So at some point, Judge Simon is going to have a fairness hearing, and the fairness hearing is a time for the court to hear from everybody, including all of you, about your thoughts on these remedies and whether you think these are fair, adequate, and reasonable ways to address the concerns that arose that are addressed in the Department of Justice's compliance report there from 2020. So I encourage all of you to watch for that. And we do send the dates to PCCEP, so watch for their website for when that will happen. But at some point, the court will hold a hearing and hopefully enter an order adopting these amendments. And once they're adopted, then that commission, the Community Police Oversight Commission, they have 18 months from that date to make some proposed changes to city council. And those changes would be, what's the structure going to look like for the Community Police Oversight Board? And how do we transition from IPR over to that new board? And then council has a certain amount of time to then consider that and make a determination about what they want to adopt. And that is all subject to the Department of Justice approval. And then once that is actually adopted by City Council, it actually changes Portland City Code. And those changes within Portland City Code, once those happen, then the city has 12 months to actually hire people, or I don't know what it'll look like, but there's going to be investigators, of course, and people who have to be decision makers on discipline, et cetera. And those people, at least some of them will be city employees, maybe all of them will be. So we'll need to get those people on board. So that we'll have 12 months to do that. And to the extent we also have in there, if there are any collective bargaining obligations, then we will expeditiously fulfill those obligations. That is a very detailed summary. I hope that's helpful. And I apologize if I went into too much depth, but I just want to make sure that you all are aware of what it says and what we've been talking about and what we had, the DOJ and the city had thought was appropriate. As I said, we will be going back to one more mediation session with Judge Beckerman with everybody. And that was on, as I said, there was the section regarding accountability. For those of you that were in court, you know this part, but for anyone who missed it, there was the AMAC and the Mental Health Association raised a concern about whether the IPR investigations to see whether police policies were followed. That they wanted those investigations. Currently, we agreed to them being for lieutenants and above, and AMAC and Mental Health Association was interested and expressed some concern about that occurring at the level of sergeant and above. And then the second area where they raised concern was around the body-worn camera policy. They had wanted specific provisions of what would have to be in any policy within the settlement agreement, rather than the settlement agreement saying that we'll bargain with the union as required, and that the Department of Justice then reserves its rights to bring us back to court after. So those are the two areas that we will have another mediation session on.
Well, thank you, Heidi. And I think we'll have Jared go next, and then I'm hoping that people are writing down their questions, because we'll have ample time for that. But thank you for that detailed explanation. So Jared, would you go next, please?
Yeah, and I don't have anything to add to the explanation that Heidi just gave about the proposed amendments 188 to 195. That was a great overview, and thanks, Heidi, for doing that. I did want to talk about the body-worn camera principles. And so paragraph 194 and the gap that was discussed in court about what a policy should have in it for a body-worn camera program here in Portland in order to be an effective remedy for our compliance concerns. And, you know, the United States has made it clear within the mediation what those principles were from our perspective. And the city asked, and we agreed to provide those principles in a letter that we'll send to the city so that they can inform when city council votes on this. It can, we'll copy the amici. I'll make sure PCCEP gets a copy of that, and eventually we'll file it with the court in support of our argument as to why this resolution is fair, adequate, and reasonable. So I do want to talk about that, and I might touch on the gap that Heidi mentioned in paragraph 192 and why we thought it fair, adequate, and reasonable to draw that line at lieutenants. And then I'll, be happy to answer any questions. I want to leave plenty of time for questions in case you all have them. But so for the body-worn camera policy, there are about, there's a lot of different provisions that go into a functioning policy. And the ones that we identified, the principles that we identified, really focus in on, what we think is important in context of this being a remedy for non-compliance. But overarching, we think that any good policy is going to be informed by public opinion. And so, we want to hear from you all, and we think the city ought to hear from you all, and the compliance officer will collect that input and share technical assistance too. And we have, plenty of experience with this across the country, and we can, give rationales for particular policy provisions we think are important. But to run down just the topic areas, and, I can give you the United States's view if you want it, but, there's a couple of questions about who wears body worn camera and who keeps the recordings. Those are two important questions that any good body worn camera policy is going to address. And we'll make statements about that as what we think is appropriate in the context here. Another big question is what are you going to use body worn camera recordings for? We think that there's valuable management uses in terms of supervision. There's valuable auditing functions that you can use these recordings for. You can use it for evidence in terms of a criminal conduct or a criminal trial, also for an administrative investigation. So if an officer uses force, this body worn camera recording is going to be very probative. It's going to be persuasive evidence as to what happened and whether any policies were violated. And so when you go through the process established by the agreement, where you write a force report and you have your supervisor review that and determine, all the way up to the chain of command to the chief, whether or not what you did, whether it's, using force or making an arrest or stopping someone and being rude or disrespectful, is that within policy? And so we think that the body worn camera evidence ought to be used for that. There's also a valuable use for training, and we think that, any body worn camera policy should address, how you can use this, expensive, but all, appropriate technology to better train your officers to perform going forward. Another set of questions that a body worn camera policy should address is when. We got the who and the what, but also when should you activate the technology during a stop, or perhaps when you're dispatched, and when should you deactivate the body worn camera recording so that it stops filming. That's an important question. There's a related question about why would we expect officers to follow this body worn camera policy? And so it's important that you have accountability to follow the policy. And so if you violate provisions of the body worn camera program, you should be held accountable and subject to the discipline process. And then finally, how do officers let you know that you're being recorded? It ought to be conspicuous. And so this how officers give notice that you're being filmed is an important question for a good body worn camera policy to restore trust rather than exacerbate distrust that might exist in communities. So I expect the Department of Justice to issue that letter to the city, in a couple of days. It's been drafted, it's being reviewed, and when that gets out, we'll share it with everyone, and you can obviously, agree, disagree, or, want further questions about that. But I'm happy to answer any questions that you have about the body worn camera policy if you have them now.
Are you done? Because I was going to wait till you're totally done and then take questions for both of you.
Yeah, I think I'm done. I mean, the one thing I want to say about paragraph 192 and whether or not we draw the line at lieutenants and sergeants, paragraph 192 is an obligation the city is really required to do now. Anytime there's misconduct, they need to investigate it and hold people accountable for any findings of, violations. that we drew the line at lieutenant was not meant to exclude the possibility that sergeants would also be investigated if there's certain misconduct that, for example, was uncovered in looking at a lieutenant. You know, if they go talk to Lieutenant so-and-so who might have trained the rapid response team to believe that they could use force against individuals during a crowd control event without, you know, having individualized justification that's appropriate under the Constitution. But that lieutenant says, no, it wasn't me, it was Sergeant so-and-so. Well, now IPR has evidence that Sergeant so-and-so violated the policy, and under the rules that currently exist, that IPR would have to open an investigation of that sergeant. And so, you know, by expressing one thing in 192, it really wasn't meant to exclude. We do understand the concerns of the AMAC and the MHA, and we'll be talking about that in mediation. I think there's a way we can make that point clear and hopefully, you know, accommodate their, you know, legitimate concerns. But with that, I think I'm done, and I'm happy to leave the rest of the time for questions.
Thank you both. I just wanted to say one thing. I was in court and heard the testimony. And to me, it sounded like accountability. Both of those issues that they want you and the city to go back and mediate on were about accountability. Body-worn cameras about how do we hold people accountable if we don't have any directives, which are the rules by which the police follow. And I think the other issue also gets to accountability. And what I heard when I was in court was that there's people that really feel that the bar should be lowered. Or those are I don't mean to make any statement about position, but that holding sergeants accountable as well would be more accountable in some people's minds. So at this time, we'd like to have a time for questions. If you have a question, if you could raise your hand.
We did perfect, Heidi. Just,
Amazing.
drop the mic and go home.
Doesn't appear you have questions, but I have a question. One thing that I'm wondering about is this letter that you're talking about, Jared. You said that it's a letter that you're drafting, and in that letter that will go to the city and that you are, I imagine, sharing with the community, is it something that your intent is that it would be used to define the policy or the directive, so it would give a vehicle to use in accountability of body-worn cameras?
So what it is the United States under the agreement, and we have authority to review policies and approve them. And what this letter is going to be telling the city what type of policy provisions we're going to approve. And so it's really us telegraphing to the city and to the public how we're going to exercise that authority we have under the settlement agreement. And that's paragraph 166. I know Barb loves when I cite a paragraph, so I wanted to just let everyone know that that authority comes there. And in this letter, it is meant to, you know, be a symbol of transparency, and, you know, but it's not going to be the policy. The policy is established by the policy review team the Portland Police Bureau has, Mary Claire Buckley and her very capable assistants, Ashley Lancaster, and I'm forgetting the other gal's name, but so they're going to draft the policy. But when that happens, we're going to be in the room and we'll have this letter and we'll be trying to guide them to draft it in a way that we think it makes this remedy effective for the non-compliance. This is our remedy for what we found as the non-compliance. And so we think that the policy should turn on, you know, being effective in context.
Thank you. Tia?
I have a couple of questions. One question I have is, will you be, Heidi, will you be recruiting at certain areas for the dean of training? Dean of training. I'm friends with some people at the Department of Education that are really into equity and diversity. And I was just, right when you said that, I was thinking that'd be a great place to recruit.
Yeah, so Tia, Mary Claire can jump in if need be, but I know that what I've heard her say is the intent, I think with the city and working with our HR bureau would be to have a national search. And so, yes, definitely, obviously people who live nearby are generally going to be more enticed to come to Portland if they don't already live here, if they're nearby rather than farther away. So, but our search will be national, and please tell people about it. We'd love to get a great applicant pool for the job.
Okay, great. Thank you. My other question had to do with the very last item. Is it really a remedy when you talk about the voters who voted for the Portland Community Oversight Board? Is that a remedy? And I have some questions about that.
I'm
Yeah,
sorry.
I'm happy to answer that. Tia, from the United States' perspective, this is a remedy we're on board with to resolve our compliance concerns with paragraph 169, which says the city shall hold officers accountable for violations of policy and procedure, and as well as paragraph 121, which has IPR timelines. This is a potential effective remedy, but we want to see it implemented. No remedy is effective if it's not implemented. And right now, there was a vote for a new oversight board. I heard Heidi say that it authorized a board, and I heard Heidi say that the city council 18 months from now will consider what to do with proposals made by the commission. So I don't know that it's going to be not just authorized, but mandated or, actually implemented. And so we'll revisit it at that point. But from the Department of Justice's perspective, we wanted to give this local process an opportunity to show us that it's a remedy. And it does that by taking, discipline power away from the chief and the chief's office, and it gives it to this new oversight board, which is TBD from our perspective. We don't know what it's going to look like. And also gives the investigation power over misconduct a lot, sharper teeth, so to speak, and giving new authority. At least that's what was in the charter amendment. But again, I think it's a great question that you ask. Is it a remedy? And, my answer really has to be, ask me in 20 months, because I don't know yet. And Heidi, you can fill in if you have any other wisdom.
The only thing I wanted to add, just so people are aware a little bit, is about the timeline. We, when this ballot measure was being devised and throughout this process, the city has been looking at other jurisdictions that have adopted community oversight boards. And we've seen some places where, they started out with a great idea, and then when it got implemented, it didn't work so well. I think right when we were adopting ours, San Francisco was having some trouble with their oversight board. So part of the timing, like why is this taking a while, is to ensure I know council wanted to ensure that they had a commission that was made up of people representative of the community, particularly those who have been historically over-policed. And then also that the actual development of what the board is going to look like, that they take enough time to come up with the right answers to it and make sure that the board is set up for success. Because we've seen ones that haven't been successful, we don't want to repeat that. We want to have one that works really well. So that's not really responsive to your question, but I know people have been asking about why is this taking so long? And I did want to let you know that part of it is to ensure we have a good process once we get there.
Doesn't it also have something to do with the PPA, the police officer union? Isn't there some pushback from that organization?
So when we initially adopted when council voted to send the ballot measure to the voters, and when the voters adopted the ballot measure, the PPA did file a unfair labor practice complaint. So that's basically a lawsuit with the with the body of the state that enforces collective bargaining rights within Oregon. And that lawsuit was challenging whether we had the right to just move forward and send this to the voters and have them approve it without first bargaining with the union. Those cases were dismissed by the union upon passage of a law that became effective July 1 of this year that basically said that we were allowed to have an oversight board if it's passed by the voters without having to bargain that. So that addressed that. There are still some questions, whether once we actually see the structure, will the union think that they have more bargaining rights? And we'll cross that bridge when we get to it. And we'll have that argument between the city and the union at that time, or maybe we'll luck out and we won't have an argument about it and we can just stand up our oversight board without arguing with them. But I think that the legislation addressed that issue, and I feel strongly that we can move forward with our oversight board.
Thank you. Debbie Iona?
Yeah, I have a question about the body worn cameras. And I know I've heard or read that the police union wants the police to be able to look at the film before they write their reports. And the Department of Justice isn't in agreement with that approach. They feel they should write their report first, then they can see the video and like do an addendum or something. So I'm curious if those 2 points of view, if there's no resolution to those two, to a compromise or whatever, or if somebody doesn't come around to the other one's point of view, what happens? Can the Department of Justice and the judge just say, sorry, we're going to do it that way, or does collective bargaining win out in this case?
So I think that the way that the Department of Justice and the city had hoped to structure it, and we'll go back and talk more with the amici, the Albina Ministerial Alliance Coalition and the Mental Health Association. So we'll go back and talk to them more about it. But our intent was to allow for any collective bargaining to occur and to occur expeditiously. So that we would get through that process. And to the extent there are differences in how a policy should look, particularly like what you're saying, when do officers get to review their body-worn camera footage when they're writing a report? Would it be before or after they write their report? That's the kind of issue that we need to take to collective bargaining and go through that process. If at the end of that process, the Department of Justice feels that we come out with an agreement between the city and the union, or if we go to arbitration and an arbitrator adopts a policy that the Department of Justice does not feel addresses their concerns, they then retain that right to bring us back to Judge Simon. And then we look at, we get into that question of who can decide. And it's a kind of messy legal issue. But once we've gone through our whole collective bargaining, it's more clear that the federal court has greater authority than if we try to have the federal court make decisions before we've gone through that collective bargaining process. Jared,
I think,
oh, sorry. There you go.
Yeah, no, I think that's great, Heidi. And the laws, state laws of collective bargaining far better than I do. Debbie, I just, I hate fighting a question or, the phrasing of a question, but the United States is not negotiating with the union in the sense of, they have a policy preference and we don't. The city and the union will agree between themselves, consistent with state law obligations, what they're going to do, and then we'll evaluate. And, I don't like to phrase it as us picking a fight with the union. We're going to, if that's picking a fight, it's picking a fight with the city because their bargaining process led them to some outcome that we disagree with. And, if that happens, we will evaluate what the city came up with and what they're putting on the table. And when we start drafting the policy, If we don't think it's an effective remedy for the notice of noncompliance, then, we'll consider exercising our rights. And that would be a jump straight to an enforcement action before Judge Simon. And that's expressed in, I think, subparagraph D or maybe C of paragraph 194. Does that answer your question?
Yeah, well, then I'm curious, then if it gets to the point where you need to get an enforcement order, then does that get incorporated into the settlement agreement? I know I was hearing that some people felt like it would be stronger to have it, as part of the agreement. And I think I even read in today's paper, something I probably heard yesterday, but didn't stick in my head, was that, then what's in writing then lives on beyond the people who are involved, until this agreement's over with. So curious about that, about the putting in the agreement itself.
Yeah, and so, if there's a motion to enforce, and we prevail in establishing that there was a breach of the agreement or a failure to comply, as we've alleged, or found in our notice of noncompliance, we don't get to pick the remedy as the plaintiff. I mean, this is where the settlement agreement is pretty unique in that, if we have to prove a breach and we succeed in that, Judge Simon then has equitable authority to devise an appropriate remedy. And so it would be Judge Simon's call. And we would have a position to take, we would have remedies to suggest, but it would be the court's hammer, so to speak, as he's mentioned before. And so, what would come out of that is, you got to talk to the judge. I don't know what would come out of that. It could be very, very interesting. And yeah, so I don't know if you have anything to add, Heidi, to that notion.
No, and I was trying to answer Tia's question, but no, I think that's correct to the extent that I missed a few words, and I apologize. That's what I get for trying to multitask. It never works well. So my apologies. I try to own it so I don't keep doing it in the future.
Hey, thanks to both of you for giving me the information.
I actually have a little follow-up question to Debbie's. So let's just playing it forward, say that does happen. You're in front of the Judge Simon again, and he makes a decision. Just say the police union doesn't like that decision, then what happens?
Yeah, at that point, I'm not the union's lawyer, but if the United States didn't like the decision, or if the city of Portland, and I can speak for the United States, we would have rights to appeal to the Ninth Circuit, if you didn't like the outcome, either from the remedy perspective or the finding of liability. I know the city has, raised defenses to the liability question. And so all of the parties, including the union, but not the amici, because they're, not technically a party, they're, a seat at the table, but they're, because the union intervened and have collective bargaining rights at stake, they would have an opportunity to appeal the judge's decision.
Thank you for that. And then my last question to follow up is, will the body worn camera, the whole program won't start until all of these things are fleshed out? Is that correct?
That's correct.
So we could be looking at a rollout of maybe a year or so until that happens.
We hope to do it faster. And we are going to, certainly on the city's end, we are committed to going expeditiously through this process and trying to move it forward. As I was saying earlier, council is considering a package of amendments to the budget that would address the remedies under the DOJ settlement agreement. One of them is money to be allotted for body worn cameras. So we are moving this forward as expeditiously as we can to meet the timelines. And under the agreement that we presented to Judge Simon yesterday, the city had 210 days from the date that the court actually orders this as an amendment to the settlement agreement. So that will, once the court actually enters an order, that'll start our 210-day timeline, which, is a one that we're going to be working really hard to meet. And we've shared that with Jonas and Jared, that'll be a hard one, but we're going to do our best. And we're going to keep Jonas and Jared informed of how we're doing and the progress we're making in case we have trouble at the end of making it within 210 days, which is, it'll be a fun challenge for us to try to rise to. So it'll be good.
It's an ambitious timeline.
Thank you. That's the word I was looking for. And
And I did want to just add one more point, because I know Debbie had a second part to her second question, and it's the idea of whether or not the policy preferences of the United States are somehow stronger if they're within paragraph 194 versus whether they're in a letter that we send to the city and attached to our memorandum in support of approving this proposal. I think it's a net push, and I know my friends with the AMAC and the Mental Health Alliance, they disagree, but let me try to explain why. Let's say, our policy preferences, the things about the who, the what, the when, the why, the how, are all within paragraph 194. And that gets, submitted to the court. We have a fairness hearing, the court approves it. Well, that doesn't make the policy preferences happen. And if the city then went and collectively bargained with the union and agreed, or were forced to agree by an arbitrator to do something different than what's in that, paragraph 194 for our policy preferences, that's only as good as the United States going to court and filing a motion to enforce because they're not in compliance with what we think are appropriate policy preferences. So that it requires us to go through the enforcement. Now, if it's not in there, if it's in a letter and it's submitted with our memorandum, and the city goes and bargains for something and they get policy preferences that we disagree with, well, this version gives us an even, an arguably stronger right to go straight to court instead of having to file a notice of noncompliance, get the city's response, go through meet and confers for 2 months, go through a mediation process. I mean, our notice of noncompliance was filed in April, and here we are in November, and we're still just finishing the mediation. So the idea that it's stronger if it's written in there now versus if it's written in a letter and we just let you know what we're going to do, and we have this sub D that says we jump straight to court. I mean, I think I'm willing to defend that what we've done here in this agreement is fair, adequate, and reasonable. I think it is. And I understand the concern of the Mental Health Alliance and the AMAC that they want that, they want to see it in ink and they want to see it in the order. But again, that order is only as good as the United States filing a motion to enforce, a motion for breach. And, so to me, it's the same. It doesn't make the policy happen by putting it into paragraph 194. The collective bargaining process, the policy approval and review process, that's what makes it happen.
And I wanted to add to that, one of the requirements under state law for collective bargaining is that we bargain in good faith. And part of bargaining in good faith means that we don't go in and say, we've already made up our mind, we're only going to do X. And so if there's case law out there that says from the state agency that enforces the collective bargaining laws in the state, that says you cannot do that. You cannot, employer or union, you cannot go into bargaining and say, I am only going to do X. I refuse to listen to you. I'm not going to bargain, because you're not bargaining, right? You're saying to them, I'm not going to bargain with you. So that's not good faith bargaining. So if the city were to go into bargaining with the union on a body worn camera policy, to the extent that impacts subjects that we have to bargain with the union, and we were saying, well, we're only going to do this, that would violate our obligation under the state law to collectively bargain in good faith. And then we're going to get all tied up in state court and slow the process down again. And I think, so I just want to, it'd be helpful for all of you to understand that both the DOJ and the city, our interest, as Jared said, he doesn't want to get slowed down on the back end. I don't want to violate my good faith bargaining obligation as part of the city. I want us to go into bargaining with the union as we have to do with good faith. And so we can't make up our mind today and say, we're only going to do this. So really, this is the best way for us to move the body-worn camera program forward and to get to a policy that addresses everybody's needs. And if we end up with a policy, as Jared said, that the DOJ feels does not meet the concerns, they will bring us back to court, and they'll be able to do that expeditiously, as he said.
And again, I'll just remind everyone, this is the product of 5 sessions of mediation. Some of them were all day, and we had a lot of smart people thinking about it. And I know I hope what we've said makes sense, at least to explain why we've done what we've done. And again, we're going to go back to mediation because Judge Simon wants us to. I don't know that this is going to change, though. It is a well thought out compromise, and I think it protects everybody's interests. And I think part of my job is to give you comfort that it does. And if I haven't, Debbie, I would encourage a follow-up question. I think Barb had her hand up, so if other people have questions, I'm fine not talking about body cameras anymore.
Debbie, your hand is still up. Did you have an additional question?
I'm sorry, I'm trying to cook dinner at the same time. I will put my hand down right now.
Thank you. And Barb, did you have your hand up? Guess not.
He's trying to entrap me and make me ask a question. I don't have one.
Oh, okay. All right. Does anyone else have a question they'd like to ask this evening? Okay, then I have another question. It actually is about the body-worn cameras. And I've heard, thank you both for presenting this evening. It seemed very, very clear to me that that there's an issue, and PCCEP is focused on trying to build trust between the community and the city and the PPB. And accountability seems to be one of the vehicles for us to do that. We've heard that. I know as a PCCEP member, I've heard from many community members that that's what they want in their city. That's what they want in their police force. So I heard in the court that people really want a little bit more of or maybe a lot more of a specific, someone touched on it. Will the officers be able to look at the footage prior to writing a report? There's another issue that I've heard people say, will the officers be able to have ownership of the video? And those to me are huge issues. So I am hoping that your mediation does go well, and that some of those things are answered, because in my mind and from what I've heard from others, those are really foundation pieces on that issue. I don't know if anyone would like to comment on that.
Yeah, I really appreciate the point, Anne, and I do see body-worn cameras as a essential remedy for the accountability violations we found. Not exclusively accountability, also in terms of force reporting and reviewing, being able to intelligently review a claim of misconduct requires the type of solid evidence that body-worn cameras provide. So it's twofold. On the accountability point, I understand your concern, and I can tell you whether it comes out of the mediation or whether you read the Department of Justice letter on Monday that clearly spells out what we think an appropriate policy in this context will do in terms of who controls, who keeps this footage. It is not the police bureau. It is the third-party vendor, and it's owned by the city consistent with state law. Like, to me, that is a very clear best practice that you can expect to read in the Department of Justice letter on Monday. In terms of the pre-review, it's similar, you know, that's the trust issue comes down to understanding why an officer used force against a civilian in any particular instance. That subjective, actual, why did you do what you did? And any officer who is an employee of this city who is authorized to use force against a civilian to make a lawful arrest or to, you know, otherwise manage a situation ought to be able to say why they did what they did without having to run to a tape. Now, it's important from the Department of Justice perspective that officers be extremely limited in any right to pre-review, that they shouldn't have it, that they should be able to write that report. And you can expect to read this in our letter on Monday, that you know, there should be no pre-review. You can review that evidence of the body worn camera recording after you write your initial report and you say why you did what you did. And then you can supplement it if you missed something, or if you see something new, or if there's something else to explain. But once you watch that video, it is unlike any other thing where you can no longer go back and capture your honest, subjective impression. Once you watch that video, it's lost. It is forever tainted by that solid piece of recorded footage that, you know, everyone else and their mother could also watch. And so that's why it's a one-time deal. You have to write down why you did what you did, your subjective impression of the threat you faced, what justified your use of force, because once you watch the video, you've lost that. That evidence can no longer exist. All you can have now is the officer's impression of what they did, why they did, when they did, based on not just their memory, but what the video shows. So it is a forever taint, and we don't think it's unfair to require that report and then go watch the video if you need to. You know, to us, that preserves both pieces of evidence. The recording is always going to be there. And if you're going to go look at the recording before you tell me why you did what you did, I might as well just watch the recording. I don't need a report at that point. And so to us, it's very important, and you will see that it's part of the trust question, it's part of the accountability question, it's part of encouraging officers to remember to be able to say and account for why they use force against a civilian. If you can always go run to the video, you're not encouraging officers to be present in the moment, to be able to remember, what am I facing? Why am I using my service weapon? Why am I using my baton or my taser or my, OC spray? Like, this is part of encouraging good policing, to write that report, then, collect whatever evidence you need to do to supplement the report. And so, yeah, we feel pretty strongly about that at the department, and whether it comes out of mediation and finds its way into paragraph 194, you can expect that the department, makes this an issue and shares our view with the public.
Thank you, Jared. Heidi, did you want to say anything about that?
My dog's barking, sorry.
I convinced your dog.
Yeah, okay. Some of the, especially the issue around pre-review, Buster, sorry, Buster is happy. Some of the issues around pre-review, one sec, there we go. Some issues around pre-review, though, that is an issue that is something that we have to bargain, and so I can't say one way or another at this time. So I apologize for that, but I do need to leave that for the bargaining process and go into that bargaining process in good faith.
And I wanted to allow Byron to ask his questions, if you'd like. You put them in the comments if you wanted to ask your questions.
No, they were pretty much answered. I appreciate the answer, Heidi. Thank you so much.
Okay, thank you. And I also saw what Barb wrote. I know that Heidi did put in the state, I believe it was the state law on body worn cameras. It's in the chat if anyone would like to look at that. Okay, so are there any other questions or comments people would like to make? Okay, I would like to thank everyone for being here tonight, and thank you to Jared and Heidi for being able to share everything that you know about the status, and we will stay posted because you will have another mediation, and then we'll want to ask you back to get an update. So thank you all. And also I did want to say that next month, starting next month, the time of this meeting is going to change. We are going to start our meeting instead of at 5 p.m. We're going to start them at 6. I've had something come up, and so we'll need to start them at 6. So I look forward to seeing all of you then, and thank you very much for being here with us tonight. Bye-bye, everyone.